First question was specifically, treaties take long to renegotiate or cancel. How it works in cases of a conflict between the countries and in cases of sanctions being imposed. So yeah, we do live in interesting times, as they say. So these are the type of situations that can pop up, and it does become a bit of a challenge. And you'll see when you have chance to read through the specific answers that none of this is too straightforward, but there are parts of this that actually, they do allow you an opportunity to do it or in a certain way, but it's not always as easy to implement it practically. The reason why I say that, and I start with that as introduction, is when you got to do with jurisdictions that are entering into some form of a negotiation or a termination or a conflict, as the question stated, the challenge is that you've got to deal with it at a certain level. Many state officials do not necessarily have the mandate, and certain of these issues could actually go very high up into government organizations or the necessary government bodies, and that makes it even more difficult. So to get to a conclusion, in many instances, you would like clarity or predictability as it impacts on business transactions. So that is just by means of an introduction. So if there is a conflict between countries and how the treaty obligations work, there are several options available. The first one is that you need to understand the dispute resolution mechanisms in terms of the treaties. Now, there's various clauses involved here, and a lot of the discussion that we're going to have on this question revolves around the Vienna Convention on the Law of Treaties, which in short is VCLT, and that's of 1969. Now, the approach varies depending on whether the treaty is a bilateral or a multilateral agreement. Bilateral meaning between two jurisdictions. When you start looking at multilateral, you involving quite a few jurisdictions. So that's why one needs to understand that. So when you look at most modern treaties, they do include these dispute resolution clauses, and they seek arbitration or resolution through international bodies, like the International Court of Justice. There's WTO, World Trade Organization dispute panels, or unilateral arbitration rules. So countries may attempt to resolve the dispute within the framework of the treaty using these, what we refer to as MAPs, mutual agreement procedures. So suspension or termination due to a material breach, which is Article 60 of that Vienna Convention, the VCLT, a country can suspend or terminate a treaty if the other party multilaterally or materially breaches its obligations under the treaty. A material breach occurs when a country violates an essential provision fundamental to the treaty's purpose, and then the affected party can invoke Article 60 of the VCLT, the Vienna Convention. Then you also have fundamental change of circumstances, which is Article 62 of the Vienna Convention, and there is where there's a fundamental unforeseen change in circumstances that was essential to the treaty at the time of signing. Then a party may invoke Article 62 of the Vienna Convention. Now, however, this principle is rarely accepted as a valid reason unless the change is dramatic and directly impacts on the treaty's execution. And then obviously one of the other situations that could come up is what is referred to as war or armed conflict. And as that says, that does suspend certain treaties many times due to the fact of such a situation because of various practical reasons. So the imposition of sanctions and treaty implications are that, sanctions imposed by a country or an international organization like the EU, just to use an example, can impact treaties in many ways. There are unilateral sanctions and treaties that actually can play out, and we all know that in certain situations you have these unilateral sanctions applied. For example, like US sanctions on Iran or Russia, or any jurisdiction that they feel that they would like to do it. Then you've got the UN or the multilateral sanctions, and that's when the United Nations Security Council imposes sanctions under Chapter 7 of the UN Charter. Then the member states must comply. And that means the member states that belong to the United Nations must all comply with it. That's why it's referred to as multilateral sanctions. Then you have EU sanctions and treaty overrides. So the European Union often imposes sanctions that affect trade, finance, and investment treaties with non-EU states. An example is where the EU sanctioned Russia in 2014. Several bilateral investment treaties between EU states and Russia were effectively suspended. That's just to give you an example of that. Then you have tax treaties and sanctions, and that's where some countries suspend their tax treaties with sanctional states to prevent tax avoidance or the use of tax benefits. And that's also, as you would think, that when you've got a dual, if you look at a double taxation agreement, there's a dual requirement or responsibility between the two jurisdictions. But when you suspend the tax treaty, then it stops. That means that you could end up paying double tax, but it's just to ensure that there's certain taxes that do come to the fiscus. Otherwise, the two jurisdictions do not credit or debit one another depending on how the transaction flow works. So an example is the Netherlands and Switzerland suspended tax treaties with Russia following EU sanctions. So treaty suspension versus termination is there are some key differences. One must understand that a suspension means it's temporarily, and that means it stops the treaty obligations, where termination is it permanently ends the treaty. You've got a legal basis on a suspension, which is a material breach or sanctions, armed conflict, where the legal basis on the termination is there's a fundamental change or breach. And if you look at the process for a suspension, it can be reversed if conditions change, where on a termination it requires renegotiation for future re-establishment. So an example of a suspension is the EU-Russia treaty suspended due to sanctions, where termination was like the US-Iran nuclear deal withdrawal of 2018. And then you still go back to the table and renegotiate. So how long does it take to renegotiate or terminate a treaty? Now, termination, some treaties allow unilateral withdrawal with notice. In other words, the one party can decide without the other party agreeing or disagreeing. The one party can just give 6 months or 1 year notice. And that period is quite common in these agreements. And as I say, the treaty will cater for it if it's applicable. Renegotiation, that can take years. And you know, there's if you go and do some research on it, you'll see that it takes quite a few years. On renegotiations and suspension, obviously can happen quite quickly, so it can happen immediately if that takes place. So what are some parting or final thoughts on this? Treaties are not easily terminated, as they are meant to provide long-term stability. And I'd like to just say it also helps business with a certain level of predictability. In cases of conflict, treaties may be suspended but not terminated. So those are just, and then they serve as tools for negotiations. Sanctions can override treaties, particularly in trade and tax agreements. So one must be very well aware of sanctions that exist when you're dealing with certain jurisdictions that are in the news for reasons that could impact on how a treaty works. And then the Vienna Convention provides a legal framework for treaty disputes. But as one would appreciate, many of these disputes or renegotiations and so forth, there's a certain level of political considerations that must be taken into account, and they play a dominant role.